Hello and welcome to Newsbreak at 7. I'm Veera Raghava. Top focus this evening. The Centre today brought to Parliament three contentious bills that could redefine archaic colonial criminal laws in the country, but also set off a new political divide. While an overhaul of the Criminal Procedure Code and the Indian Penal Code has been a much debated issue, some of the aspects of the bills brought to Parliament could be extremely contentious and politically divisive. It will be referred to a parliamentary committee. To start with, the Indian Penal Code will be called the Bharatiya Nyaya Sanhita. The Criminal Procedure Code will become the Bharatiya Nagrik Suraksha Sanhita, and the Indian Evidence Act will become Bharatiya Sakshya. Now, there were strong responses to this already coming in from Tamil Nadu Chief Minister M.K. Stalin, who says that the naming of the bills in Hindi could be construed as a case of Hindi opposition. The other aspects of the bill, including 20 years changes, includes 20 years punishment to life imprisonment for gang rape, death for rape of a minor. Those absconding can be tried in absentia. Update on FIR is compulsory according to the new laws in 90 days. 0 FIRs could be codified in law. For the first time, community service as punishment for petty crimes also introduced. While the word sedition is removed, offences endangering sovereignty and unity of India is brought under section 150 of the Bharatiya Sanhita Suraksha Bill. Several other changes, several other aspects which could well become contentious both politically and legally in that bill. This is what Home Minister Amit Shah had said after the bill was brought to Parliament.
जो कानून रिपील होंगे इस तीनों विधेयक से, वो कानूनों की आत्मा जो है, वो कानूनों का मध्य बिंदु है कानून बनाने का, वो अंग्रेज शासन को मजबूत करने की दृष्टि से कानून बनाए गए थे। इनकी जगह जो 3 नए कानून बनेंगे, उनकी आत्मा होगी भारत के नागरिकों को संविधान प्रदत्त सारे अधिकार जो मिले हैं, इसकी सुरक्षा।
We'll have a panel of an ex-police officer and lawyers to discuss the potential consequences, implications of these three bills. Ashutosh Srivastav, advocate of the Supreme Court, he joins us from New Delhi. Advocate S. Balan, senior advocate and a human rights activist from the Karnataka High Court, he joins us from Bengaluru. We hope to be joined by Mr. L.N. Rao, former Deputy Commissioner of Police, Delhi Police, in a bit from now. But first to you, Mr. Ashutosh Srivastav. It's already becoming contentious with political reactions coming to the naming of the bill. What do you think are the key aspects of these three new bills that have been brought to Parliament, the ones that could be most contentious?
See, if we consider the 2022 order of the Supreme Court, wherein the Supreme Court had stated the implication of section 124A of the Indian Penal Code, which talks about sedition. Saying that it has become a very old age law and which is being misused. That was the contention, and there should be some rethought by the government that there should be some change in the law. And accordingly, I think it is not only 124A, but there are many other provisions. I think from time to time, every country has adopted certain changes, and accordingly, considering the crimes and you know that it should basically target to the justice part of it. Nowadays, if an accused, a person who has just been alleged of an offense, if his name is implicated, it takes a long battle or long time for that person to prove that whether he has committed or not, or even to get a bail. It becomes a long task. So now certain rules and regulations which will be making amendment in the Indian Penal Code, the Criminal Procedure Code, and also the Indian Evidence Act, that will have some far-reaching effect so far as the orders or the judgments of the courts are concerned. So it is I would say that it is a comprehensive kind of a change in the criminal law system, and it is aimed at bringing justice to the people rather than only for the purpose of punishment. That the old era law which was being continued as of now. So I think there are many other aspects also. Right. For instance, obviously that the person will have, the self-defense grounds also if anything goes in that way. Or, there are certain changes which are aimed to protect the justice, the legal justice system for the people. So that I feel that there should not be misuse at the same time. That is the thing which has to be handled in a proper way. So the government is coming up
Right.
saying that the hearings and things like that will not be delayed by the judiciaries. So that if that is considered in a proper manner, then I think the changes will have a better impact on the criminal legal system in the country.
Okay, let me just get Advocate S. Balan here for another point of view on this. Sir, obviously there has been a long debate and there has been a desperate need in terms of overhaul of what has been called archaic and colonial laws. What do you think could become potentially most contentious? Because remember, this will be studied by a parliamentary committee closely.
Yes, sir. Yes, sir. See, 511 IPC sections, 484 CRPC sections, 167 Indian Evidence Act. This is time tested by the Indian judiciary by way of several judgments. Now the very name change, Bharatiya Nyaya Sannita. Sannita is a moon word, it is astrological word. Then Suraksha, Bharatiya Nakarik Suraksha, Bharatiya Sakshya. These are all Vedic and saffronization. I feel that there is an attempt on the part of corporate saffronization of Indian criminal judicial system. Since in the year 2003, the very same NDA made an attempt to amend the entire criminal law by appointing Malimat Committee. Malimat Committee is in violation of the constitutional principles. Again, when NDA come to power in the year 2018, they made an attempt. Now 2023 also they made an attempt. See, there are basic principle is Article 20 Clause 3, right against self-incrimination. Article 22, arrest and fair justice. Then no presumption, proof beyond shadow of doubt. Proof beyond shadow of doubt. All these things are thrown to winds. Now, what the Home Minister wanted is 90% conviction. Now, you see, it is already incorporated in Unlawful Activities Prevention Act, where there is part of the many provisions of IPC is named as scheduled offense. Then Prevention of Money Laundering Act. Now bail is impossible. Now the entire matrix of the case, if it is taken into consideration, see 90 days, charge sheet should be filed within 90 days. Now the attempt is made to stretch it to 180 days. Then the Home Minister wanted more capital punishment. That is against to the principles of the Constitution. Next, sir, 1 second, I'll complete it. Section 25-26 of the Evidence Act in consonance with Article 20 sub clause 3 of the Constitution, this is anti-constitutional. This is anti-national.
Okay,
this
I will have to move to the, I get your point. We'll get a response as well. Mr. L.N. Rao can finally join us after those little technical difficulties. Sir, your first thoughts. We've had two very strong points of view. One which believes that there is a complete overhaul of the system that was necessary. Another which believes that it's anti-constitutional and that some of the provisions could be in violation of rights. What is your point of view as far as the new laws that have been brought, new bills that have been introduced in Parliament?
Yes, good evening to you and all your viewers. So far as I could gather the information from the about the new bills which are being introduced in the Parliament, and now I think they have been sent to Select Committee for their opinion. I think that the clauses which have been read, these are incommensurate with the present situation in India, because the earlier laws are laws from the very old time, and then as you can say that that Evidence Act was 1808 and 1872, and then Indian Penal Code was 1861, and the CRPC, of course, it was being amended from time to time, but not with perspective of overhauling all the system. I think that that was a need of hour from the earlier time, there was a demand that because of this investigation is not completed within a stipulated period, and the investigation is not supported by the scientific evidences. And now with this bill, I think the police reforms will also have some gather some importance about all these things, that the scientific investigation is to be corroborated as a very prime evidence, and this judicial system also being revamped like this. But I think that there may be some problem initially, because the system, as and when there is a change in system, I don't think that is a totally change, but it is something, it's a significant change in being done, the introduction of these bills. And there may be some problem in the beginning, but I think that these are for the all betterment and the interest of the public, general public. And this will have a long way in reforming
that's your take.
The system and the police system. Yeah.
That's your take. Let me get Ashutosh now, sir. You heard what Mr. Balan said. Your quick response to what Mr. Balan said, and then I'll get Mr. Balan to respond to what you say.
See, I would say that saying it to be unconstitutional will not be the right way of saying it. See, it is not unconstitutional or anything. Even the Supreme Court has struck down many previous sections of the IPC, if we see, and even 124A sedition, or maybe we had 497 earlier IPC. So even Supreme Court has struck down certain sections and have made certain changes in the entire legal system. So I think with the change of the time, I feel that there should be introduction of obviously certain rules and regulations or laws which have been actually recommended by the Law Commission of India, and that should be respected. So far as the names or the other things are concerned, that is a separate issue. Whether you call it by any English name or a Hindi name, that I am not commenting onto it. But only one thing I would say, that while making or framing these new laws, only that the innocent people should not be dragged in such kind of a situation where their names are implicated in any FIR or anything. And there should not be misuse of law. That should only be considered by the government. That is what is my view.
Okay, let me get Mr. Balan to quickly respond. Mr. Balan, your response. There was a need or there wasn't a need? What do you think would be the most contentious part? Where Mr. Ashutosh can say what's in a name, but it seems different from south of India.
See, India has several nationalities, several language, religion, but it indicates that the names are connected to a particular religion. See, I am a trial lawyer. I know what is going on in the trial courts. See, who are being arrested, sent to jail? There are people languishing in jail for years. See, now what I heard from the talk of Honorable Home Minister, it is only a bald and a very vague introduction of these three bills. See, I read the complete the report of Justice Malimat Committee. I read the report of 2018. 2018 and 2003 criminal law amendment proposed by NDA government is... See, burden of proof. If burden of proof lies on the accused, that is unacceptable in the international governance. Burden of proof, fair trial, right against self-incrimination.
You're raising some very important points. I just want to get a final last word from Mr. Rao. We're running out of time. I'm sorry, Mr. Balan, we're running out of time. You're raising important points. Ashutosh has also made his argument. Mr. Rao, your final word on this, last 20 seconds. Mr. Rao.
Yes, the Parliament has a prerogative to change the laws as per our Constitution of India. But I also agree with Mr. Ashutosh that even the Honorable Supreme Court has also amended so many other laws during the past when their judgments are being done, and on various judgments there are some amendment has been done, and the Supreme Court has also considered so many things which are not applicable right now. They have already, as per their judgment, they have been done. But the final verdict is of the Parliament to amend any law. by the enactment and with the Lok Sabha,
Okay.
Raj Sabha, and then Honorable President of India.
The matter-
The final assent to that bill.
The matter will come up before a parliamentary committee for further scrutiny, but it's already started that the political divisions between North and South, as far as the name is concerned, with that political comment coming from the Tamil Nadu Chief Minister and opposition, expect more of that from perhaps some of the other southern states as well. But that's all we have time for. We'll keep on this debate. We'll keep a close focus on the progression of that bill. Thank you three for joining us and sharing your thoughts.